The third example I want to talk about raises a combination of the issue of independent contractor and the exchange of services for something of value in determining whether or not the plaintiff is a worker. Now, in this tribunal decision, the plaintiff was a 36-year-old with a Bachelor of Science degree and an equestrian coaching qualifications. And the defendants were owners of a horse farm that was located near the plaintiff's home. The plaintiff dropped off a resume at the defendant's farm looking for a position that was based on her knowledge of horses and her willingness to work hard. Now, the defendants didn't have any employees at their horse farm. They did all the work themselves, except once in a while they would hire teenagers for a few hours to help them clean out the barns. But they decided to take on the plaintiff, but no written contract was entered into and no formal payroll was set up. They did agree, however, that she would be compensated at the rate of $8 an hour and that the task would be to clean the stables, to feed and exercise the horses. In addition, they said that the plaintiff could give riding lessons at the defendant's farm using the defendant's horses, but she wouldn't be paid by the defendants for doing this. She could charge those students directly. And the plaintiff did that. She charged students $25 an hour. One day, the plaintiff is training one of the defendant's horses, and the defendant's dog comes out, startles the horse. Plaintiff is thrown, and plaintiff sues defendants because of her injuries. The defendants moved for a declaration that there was no right to sue. The plaintiff took the position at the tribunal that she was not a worker at the time, she was an independent contractor. So the tribunal, in assessing the evidence, looked at the test for assessing whether or not someone's an independent contractor, or they're sometimes called independent operators. They looked at the test you've probably heard of, the organizational test. They looked at the Workplace Safety Insurance Board's policies documents, which contain charts comparing the characteristics of independent operators against the characteristics of workers. And that chart's very much like the one that Canada Revenue Agency uses in determining whether someone's an employee or an independent contractor. And the tribunal looked at court decisions on the issue, such as the Sagaz Industries case. The tribunal in its decision said they were influenced by a number of factors. They said that the fact that the largest part of the plaintiff's income was the $8 an hour that the defendants paid for cleaning and training horses was important. The fact that there was an hourly rate used to calculate her remuneration meant that she had no chance of profit and she had no risk of loss. And she did not control the rate of pay. She couldn't choose to charge $9 instead of $8, or she wasn't charging by the task. So, and even though she was working without any supervision, she took general direction from the owners of the farm, and that was enough to meet the control factor. And also the tribunal pointed out that she did not work for anyone else in doing cleaning and training of horses. The tribunal considered the fact that there was no payroll deductions. They said that was significant in terms of independent operator fact, but they said that was balanced by the fact that the plaintiff had not really taken any steps to take a GST number or register as a business. They did recognize, however, that she had, on her income tax returns, treated herself as a self-employed person and claiming expenses against her income. The tribunal pointed out that the defendants owned everything needed to do the work. The tribunal commented on what can be a bit ironic, I suppose, in terms of the evidence, that the plaintiff thought she was running her own business in doing the barn cleaning and doing the training and also doing the teaching of horse riding to students. And the defendants testified much the same. They didn't think of her as an employer. They thought of her as some kind of independent operator. But the tribunal pointed to some paperwork in the file that became part of the evidence that after the accident, the plaintiff had applied for employment insurance benefits. And they said that indicated that she felt she was employed and that she had listed the defendants operation as employment, and also said that she had self-employment from riding. In the end, the tribunal held that only the riding lessons part of her operation could meet the independent operator aspect, and that because this injury didn't occur when she was teaching riding to students, she was a worker of the defendant farm owners. I can tell you there's another decision of the tribunal on similar facts. The difference was that in that case the plaintiff did chores in exchange for the opportunity to use the barn and the barn owner's horses to give lessons for which she billed her own students directly. The difference was that the cleaning chores were not paid. It was completely a provision of services for the opportunity of making money doing teaching. And in that case, the tribunal held that an injury that occurred while doing the chores was one that occurred as a worker for the owner. The owner was a Schedule I employer, and the plaintiff's right of action was taken away.